All right, we may get a couple people who are still going to filter in, but I think we'll go ahead and get started with our presentation. My name is Scott Reigle. I'm a shareholder with Meissner, Tierney, Nichols. This is my colleague, James Sosnoski. You heard from Adam Tutai, one of our other shareholders. Right at the top of the presentation, he gave you some remarks to give you a little more information on the firm. As he said, we're a firm of about 22 people. We're full service. We do everything. We do transactions. We do everything through litigation. James and I happen to be more on the litigation side of things. Specifically, we practice in the commercial litigation space. James is pretty much a pure litigator, and he also has quite a bit of appellate experience. He actually came to us a few years ago from the Wisconsin State Supreme Court. And my practice straddles the field a little bit from litigation to what I like to think of as litigation prevention. So, and that's just a fancy way of saying, how do we structure things properly to move your business forward? So, before getting into the remarks, we have to give the lawyer's disclaimer here. Nothing that we're going to give you is legal advice. This is all just very high level. It's going to be a 35,000-foot overview of the strategies that we're talking about to secure your innovation. In this room we have innovators, we have entrepreneurs, we have a lot of people who have an idea, something that makes your business special. And what we want to do is help you think about how we can comprehensively create a web to protect your innovation. So often, what happens with entrepreneurs and innovators when we're working with them is they have a great idea. They know what it is, and they go after it. They go after it doggedly. They build a business around it, and they're going, and then they get a couple years down the road, and they realize, oh, we have all these problems. How do we solve them now? Because you didn't do the work on the front end. Now, that's not to say they did anything wrong. They did what they knew how to do. But by being proactive, by building it correctly at the front end, you can head off a lot of problems. We're going to be a little bit more targeted in the topic we're going to talk about today. We're going to talk about how do I protect that idea, that secret sauce, whatever that may be, of my business that makes us special. How do I keep our competitive advantage in-house? So, James, if you want. So, we're going to kick off with the thing that everybody loves to talk about, which is, of course, policies and procedures. These are the types of things that entrepreneurs and innovators and even just business people in general, you don't want to think about it, but they're critical to running your business. Now, I'm not going to talk about every type of policy and procedure you can have. We're going to talk more about policies and procedures you put in place to protect that innovative idea. As I said, there's going to be something about your business that makes it unique, something that gives you the advantage. So, how do we protect that using policies and procedures? Well, the first thing is you need to have them. They have to be clear and they have to be communicated. The most frequent way to do this is through something like an employee handbook. Many businesses have them. I'm sure that we've all been in an employment situation where you walk in on the first day and they give you an employee handbook. It's probably 1.5 inches thick. And then they put a sheet of paper and they say, sign this to acknowledge that you received it. And nobody ever looks at it. And that's for us, that's for the lawyers, because then it's very hard for somebody to deny that they were given the opportunity to learn it. But the important thing is having policies and procedures about especially your data, your secure information, that your employees know and understand and will follow. So for example, when you're talking about a business with a sales force, for example, it's very critical in many cases to keep our customers and our sales leads in-house. We don't want that information getting out. How do we do that? We make sure that only certain people within the organization, i.e. our sales force, has access to that. You can build that in through the use of different technologies, but also just through norms in your company. And again, that's where clear, communicated policies come into play on that front. And also, part of that is we have to keep the circle small. It's important that everybody in the organization has the information they need, but we want to make sure that people have the information that they need only to the extent that they need it. If we allow everyone to get access everywhere, it's going to be very hard later on for me to stand in front of the judge and say, well, Your Honor, this was very confidential, highly proprietary information. He said, well then, why does the secretary know it? You have to be sure you're keeping your secure information secure. Whatever method you use to do that, there are many routes getting to that conclusion. We talked a little bit about the employee handbook. Written policies and procedures are always great, but the important thing again, they need to exist, they need to be communicated, they need to be clear, and everybody within the organization needs to understand them. So here I'm going to turn it over to James. Oh, before we do that, there are certain concepts within the law, and every employee owes to their employer what's known as a duty of loyalty. Now, it exists on a sliding scale. People higher up in the organization, we're going to talk about this a little later on, will have a higher duty of loyalty. People lower will have a lower one. But the point is, and you can see the definition here from a recent appellate court decision, to refrain from taking actions within the scope of the employee's responsibilities that were directly contrary to the employer's interests. And the example that we put on the slide here is diverting business opportunities. So every employee has this duty, and they do exist within the law. Even absent a written agreement encapsulating this, that can still, it still does exist. Same with confidential information. There's certain types of information that need to be protected. Now, what James is going to talk about is how do we use specific agreements with our employees to better secure those things so that we're not in a kind of a mushy common law area. We're in more of a written, very formalized type agreement. So James?
Yeah, so a couple of ways that you can take more formal action to protect either confidential information or to protect your business are through these sorts of protective agreements. And three of the most common ones that you run into are non-competes, confidentiality agreements, and non-solicitation agreements. All of these are what we call in the law restrictive covenants. You get your employees to sign them, and then usually for a period after, for a certain period after the employment ends, these agreements are binding. So a non-compete
And during employment.
And during employment. That's a little bit easier to enforce because it's during the term of employment. But so like a non-compete agreement will typically take the form of, the employee promises not to compete in your business in the exact same area for a certain period of time afterwards. Confidentiality agreements say, are for both during and after the employment. The employee promises to keep certain sensitive information confidential and not use it to the detriment of the employer. And then your non-solicitation agreements can protect usually one of two things, either preventing the employee from soliciting your own customers. For instance, if you have a salesperson, you don't want them taking your customer list and then going and soliciting all of your clients. But it can also be a non-solicitation of employees. So if you heard several of the award recipients talk about how important it is to retain good people. If you've got a key team, you lose one person, and that one person then starts poaching all of your best employees. These are all types of things that you might want to spell out in an agreement. Now, here's where the difficulty kind of starts. When you're talking about restrictive covenants and these types of agreements with employees, they receive heightened protection under the law from unreasonable restrictive covenants under Stat 13465. And basically what that means in common English is restrictive covenants with employees are difficult to enforce, and you have to write them very carefully because courts are going to scrutinize them, and they're not going to be enforceable unless they are narrowly tailored. And on that note, this is why it's important to draft them carefully. You can't get partial enforcement in Wisconsin. It's kind of an all or nothing deal. If you draft an overbroad covenant, it doesn't just get restricted by the court, it gets completely struck down. So you might have spent all this time and effort securing these agreements with your employees to protect your idea, to protect your innovation, and then only to have it all just be completely unenforceable. So a couple of tips. As I already mentioned, you don't draft a one-size-fits-all agreement for all employees. You should include reasonable geographic and time limitations, and just generally make the agreement as narrow as you need and no more expansive than what you actually need, because courts are going to look at it very carefully, And there are lawyers who make their entire business out of getting these restrictive covenants struck down as unenforceable, but they can be very necessary. And I guess that reminds me of something else that a couple of the award recipients said, kind of the importance of bringing on counsel at key times in developing your business. When you're starting off and you're building that team and you've got that core group and you want to protect that, or you want to protect your sensitive information, getting attorneys who know how to draft good restrictive covenants is a good portion of that. So a couple of no-nos to keep in mind with these agreements. So one thing that comes up a lot in law is what we call the janitor rule. And that basically what that means is you can't, it goes to the breadth of how broad your restrictive covenant is. For example, if you're drafting a non-compete, you have an interest as a business in keeping your CEO from leaving and going and starting a competing business. You can draft a restrictive covenant for that. You probably don't have the same level of interest in telling your janitor that your janitor can't go work for somebody else for a couple of years after. That's why it's called the janitor rule. And similarly, Scott and I were actually talking about this yesterday, you can't tell your CEO that he can't go work for a competing company as a janitor because that doesn't really hurt you. So it's an extreme example that actually comes up in the courts a lot, but the reason it comes up is a lot of these stock kind of non-compete agreements, like if you go online and you look for one, it's just going to be, you can't compete with us in any capacity after you leave. And so there's no restriction on the type of work, or it's a non-compete that all employees are required to sign. Or in the case of actually a relatively recent court case in Wisconsin, it was an employee non-solicitation agreement that applied to all of the employer's employees, even the janitor, and that's when the janitor rule came up. Yeah.
And just the gravity of this is very serious, because I can't tell you how many clients we've worked with who said, I just lost my best salesman. He's got everything in his head. That's a whole different thing. But he knows all of our clients. He's going to be able to go over there, and he went to a competitor. He's going to take off. But don't worry, we've got a non-compete agreement. And they slap it down on the table, and you go, I hate to tell you this, but no, you don't. Like, no court's going to enforce it. So this is something you always want to be very careful about on that front end, because, again, one slip up, you can lose the whole thing.
And I think that gets back to something you said at the start of you being in the business of litigation avoidance. Like, I typically come on when these things start getting litigated. That's a big part of what I do. So I kind of see the aftermath. But ideally, what you want is for these things to be drafted correctly on the front end, so that you don't have these problems. Like, either you're going to win your court case, or ideally, it's a strong enough non-compete that when that key salesman or saleswoman or salesperson leaves, they go to a lawyer and say, hey, can I get out from under this? And the lawyer says, yeah, this is pretty airtight. Your chances of success are low, and there's no lawsuit at all. So you also have to keep in mind geographic limitations. Typically, with your non-competes and other restrictive covenants, you can't just happen to be everywhere in the world. You have to be restricted to a specific geographic location. And as a general rule, any kind of restrictive covenant that lasts longer than 2 years is going to be deemed overbroad. 2 years seems to be about the happy medium. It is kind of a sliding scale. There's a bunch of factors, but that seems to be about as long as courts are going to let you enforce it.
Yeah, and before we move on from the last one real quick, particularly with geographical limitations, because this is something that you run into. There are a lot of times you'll see in these agreements, you'll see radius restrictions. So you can't work either within the state or within the United States, or 25 miles from our principal office, something of that nature. Now, it's very fact determinative whether or not that's enforceable. And when James talks about avoiding using stock agreements, I'm going to try and anonymize this as much as I can, but I was dealing with a situation where an employee had a non-compete with a geographic restriction of X number of counties, because this was right around where this employer was based. The problem was this employee only did work with clients that were on the East Coast, far away from where these restricted counties were. So not only was that arguably not that useful to that company, Also, the court's going to look at that and go, well, why do you need this? Why, if this person's expertise is all on the East Coast, why can't they work in Dodge County? You know, what does that restriction do for them? So, geographic limitations, you got to think very carefully about what you're doing with those. And anyways, as James has already said, 2 years, that's about the most you can get out of an employee.
And one final note, getting back to the idea that you just can't make these one size fits all. You know, a lot of businesses, even ones that are more local to Wisconsin, will have employees in other states, and another state's law might apply. And Wisconsin's pretty restrictive as far as interpreting these covenants. Other states might allow you to have a broader restriction, or as in, you have some experience in California, other states are even more restrictive than Wisconsin.
Yeah, I was a practitioner in California for about 8 years before coming back here to Wisconsin, and they actually have a statute there which, in essence, says if you think you have a non-compete with a California employee, no, you don't. They can't be restricted. There are very, very narrow limitations within which they can. And that's a big problem, especially for Wisconsin businesses, California being the size of the market that it is. It's not atypical for somebody to have, oh, we've got an agent in California, we've got a salesperson out there, whoever it may be, and you think you've got them locked up in a restriction. Well, no, you don't. The California courts are going to apply their law, and they're going to knock out your restriction in all likelihood. So you've got to be very careful dealing with these things. And that's kind of why we're talking about the web of protection. You can't count on any one particular thing, but by creating a web, you can really keep your innovative ideas in-house.
As to the next portion of the web, Scott, you talk about these protective agreements in the context of owners, partners, et cetera.
Right. So right to this point, we've been talking about your employees, but now we're sort of more on that management ownership level. We talked about earlier that duty of loyalty and how there's a sliding scale. Well, when you get to that ownership management level, these types of people are going to have what they call fiduciary duties. And really all that means is that they have an obligation to put the interests of the organization above the interests, or above their own personal interests. People don't always do that. You see it in the news all the time, but that's the general idea. Now these duties, much like the duty of loyalty, it exists at law already. You don't necessarily need a written agreement to do it, and when it comes to owners, officers, the fiduciary duties are going to be much more strictly enforced by the courts. They're not going to apply the sliding scale quite as easily to them. However, that's not to say that you can't have or shouldn't have the same types of formal written agreements that we're talking about. You can have any of the same types of agreements, and actually, when you're dealing with owners especially, but it can also, in certain instances, apply to key employees, you can get greater restrictions than you could under a general employment agreement that typically comes up in the context of the sale of a business. But if there is a sale of a business, you can get, again, much greater restrictions than you could on your employee. You can get longer durations, you can get wider geographic areas, you can restrict them from doing more activities. And those can be taken care of in advance, not uncommon for example, a written agreement to exist between co-owners of a business that will say what happens when one of us disassociates. We'll already have, before this person disassociates, baked into the cake, this is what you're going to be restricted from doing, for how long, for where, and any of the types of things that James was talking about in the employment context, again, exist here. You just have different options. So.
Yeah, and one final note on that. In addition to being able to get the protections against ownership, spelling these things out in formal agreements can help foster trust, especially when you're talking about partners and owners. The saying is good fences make good neighbors. If you spell everything out on the front end, you very in detail lay out how dissociation works and what's going to happen. It can preempt a lot of disputes.
So agreements with third-party vendors. So, kind of broadly, we've been talking just about threats from within to this point. My employees, my co-owners, my partners. So now we're going to move a little bit more to threats from outside the organization. Especially as entrepreneurs and innovators, My guess is that you're probably either in a startup mode or cash might be a little tight. So you're probably outsourcing a lot of functions that maybe a larger entity might bring in-house. The examples that I would think of right off the bat, a lot of startups would outsource accounting functions, legal functions, of course. But in those instances, professionals like that would have fiduciary duties to you. So similar to what we were talking about earlier. It's the types of organizations that wouldn't necessarily have fiduciary duties that we really need to worry about. So I may be great at producing widgets, whatever that is, but I may have no ability to sell them. So I can contract with all kinds of outside sales organizations that would be more than happy to sell my widgets for me. But in the process of selling those, they're going to learn a lot about my business, and they might learn what that, the recipe to Coke, whatever that is, of my business. And so when we structure agreements with outside vendors, we want to make sure that we build in confidentiality protections. We want to make sure that information that is shared only gets used for my benefit, that it can't be taken outside of that relationship. And again, anytime you're not dealing with somebody who's going to have some sort of fiduciary duty to you, you're going to want to be very careful about how we structure these agreements, making sure that these protections get built in. All right.
I think that brings us to kind of the final bit of this, which is the intellectual property, which we could spend a very, very long time on it, and which we do not have. And it's an entire subject on its own, but it's one more thing to consider especially if you have a lot of intellectual property. And the two biggest portions of intellectual property protections would be trade secrets and then patents, which are kind of different. And on the trade secret front, which is it's non-public information. Like, you do not disclose this to other people. Other people can't see it. That's kind of what makes it a trade secret. Getting back to the very beginning, what Scott was talking about, in crafting the right policies and procedures. A key part of protecting trade secrets is keeping it secret. So as part of your policies and procedures, you're going to want to very carefully restrict who has access to that, or you could potentially lose your trade secret protection. And I guess the only other additional thing I would note is trade secret is very separate. Trade secret protections that you can get in agreements with your employees are separate from other aspects of the restrictive covenant. In fact, the statute basically doesn't apply to trade secret protections that may be available under the law for trade secrets.
Yeah, and I think that is a good point, that you can avail yourself of trade secret protection even in the absence of an agreement, but that requires you to structure things properly within your organization and deal with your confidential information properly. So then, as James mentioned, there are other ways that you can protect your information, and again, we could go on for full-day seminars about any one of these topics, but the big three would be patent, trademark, and copyright. All of them have their own advantages and drawbacks. Patents, a lot of people use them, and they can be an effective tool. But typically, if you're going to patent something, you got to be ready for the fights. And the other thing is you make your information public when you patent it. So you do get the protection for a certain period of time, but you're making your innovation public when you do that. And so somebody can come in and try and tweak it, and then you're involved in a 10-year court battle over, well, did they really violate my patent or not? So it's a consideration you got to take when considering whether to patent an idea, because there are a lot of entrepreneurs and innovators who say, I'm better off just trying to protect this thing in-house and never putting the information out in public.
Yeah, and I think to sort of wrap this whole thing up, one of the key takeaways is that protecting your business, it's a comprehensive endeavor. It's not just getting a non-compete. It's not just getting a non-solicitation agreement with key employees. It's about considering the business as a whole and considering what protections you need, where your vulnerabilities are. And that's why sometimes bringing on a legal partner is a really important thing to do.
Yeah. Well said, James. So we are out of time, and my guess is you all have day jobs too. So we'll stick around to take questions if anybody has any. Otherwise, we can stick around after the presentation. Our contact information is up there. Website, we're right downtown here. If you guys ever want to stop by. But yeah, and feel free to use our website. There's a lot of great resources on there, especially for people in the small, medium, closely held business world. So with that, we will wrap. Anybody have any questions they'd like to throw out? Otherwise, we'll be here for a few minutes after the presentation.